Breaking news out of the United States District Court for the Western District of Washington State. A major ruling involving the state's so-called large capacity magazine ban. Stay tuned, I'll give you the details in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Breaking news that just came out of the United States District Court for the District of Washington, the Western District of Washington. An attempt by the government of the state of Washington and several other state officials to try to escape liability in a legal challenge involving the state's so-called large capacity magazine ban has failed. The federal court refused to dismiss the challenge brought by several plaintiffs, including a company called Rainier Arms, the Second Amendment Foundation, and the Firearms Policy Coalition, on the grounds that indeed the plaintiffs have established standing to be able to challenge these laws, and under federal law, indeed, they were allowed to sue and demonstrate that this so-called large capacity magazine ban is unconstitutional under the Second and 14th Amendments to the United States Constitution. As you may recall, just as a reminder, under the Washington state statute, it specifically says that it is outlawing the manufacture, importation, distribution, and sale of so-called large capacity magazines. Now, these large capacity magazines, of course, is a euphemism. It's a propaganda term for what are standard capacity magazines that hold more than 10 rounds of ammunition, which is basically virtually almost every semi-automatic gun in America. In fact, we know that these so-called large capacity magazines, these standard capacity magazines that hold more than 10 rounds, are ubiquitous. They're all over America. They are definitely commonly owned by Americans for lawful purposes, because we know, according to the National Survey of Firearm Owners in 2021 and 2022 by Georgetown professor Bill English, there are literally over 500 million, that's billion with a B, and certainly 500 million large capacity magazines exceeds the 200,000 stun guns that the U.S. Supreme Court said was commonly owned by Americans for lawful purposes in the Caetano versus Massachusetts case in 2016. You don't have to be a math PhD to conclude that 500 million is larger than 200,000. So obviously these so-called standard capacity magazines that hold more than 10 rounds are going to be deemed commonly possessed by Americans for lawful purposes. That's what's going to ultimately happen. But the government, fearing, in my opinion, that they were not going to be able to win on the merits, desperately tried to get around this by moving to dismiss the case for a lack of subject matter jurisdiction, for a lack of standing, for all sorts of other arguments, and the government failed. There was one aspect of this case that was dismissed. Specifically, they said that claims brought by the plaintiffs under 42 U.S.C. 1983 were dismissed. It's a practical matter. It doesn't matter because the plaintiffs are seeking injunctive relief. Injunctive relief means stop the government from enforcing a law. That is in contrast to monetary damages, where you are forcing the government to pay you money for damages you've suffered. In this case, the plaintiffs seem focused on injunctive relief, stopping the enforcement of this absurd ban on the sale, distribution, and whatnot of these standard capacity magazines that hold more than 10 rounds. So the bottom line is that congratulations to the Second Amendment Foundation and to the Firearms Policy Coalition. They have a major win today in the United States District Court for the Western District of Washington. The challenge to the so-called large capacity magazine ban in Washington State will move forward, and that is great news for the Second Amendment, because I don't see how the state's going to be able to defend successfully the ban on these large capacity magazines / standard capacity magazines based on the Supreme Court standard of review that they set forth in NYSERPA versus Bruin, specifically to show there's some sort of ban on magazines in 1791. It ain't going to happen because there are no such restrictions. And again, the fact that these are modern, you could argue, allege that these are sort of more modern inventions. They're really not, by the way. That's right. Even if you assume arguendo that these large capacity magazines are modern firearms as opposed to been around for a very, very long time. The reality is they're still protected because we know that the U.S. Supreme Court has said repeatedly that modern firearms are protected even if they did not exist in 1791 when the Second Amendment was effectuated. Okay, congratulations to the plaintiffs in this case. Congratulations to Rainier Arms, Second Amendment Foundation, Firearms Policy Coalition, to Gabriella Sullivan and the other plaintiffs in that case. Great job. We're looking forward to hearing more great things out of Washington as you kick the government's butt out there and you declare their so-called large capacity magazine ban unconstitutional under the Second Amendment, which in my view, it undoubtedly is. Okay, hope you learned something here at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.